Welcome to Lesson 6 of the Basics of Immigration Law course. In this lesson, we'll dive into visa types, eligibility, classifications, supporting documentation, grounds for visa denial, the visa issuance process, what adjustment of status means, and how to file for it. Let's get started. As we saw in our previous lessons, the U.S. Immigration and Nationality Act is the primary body of law governing immigration and citizenship in the United States. Its key functions include defining the types of visas available to foreign nationals, outlining eligibility criteria and application processes, and establishing grounds for the refusal of immigration benefits. Let's look at the different types of U.S. visas. Visas are granted based on the applicant's intended purpose of travel, and INA classifies visas into two broad categories: the non-immigrant visas, like a tourism visa, and the immigrant visas, which are for permanent residency. Now let's take a closer look at the non-immigrant visas. NIV are for individuals who intend to stay in the U.S. temporarily. They must apply for a visa that matches their purpose of visit, such as tourism, business, study, work, and exchange visitors. Non-immigrant visas do not guarantee entry. Upon arrival, the applicant must seek admission from U.S. Customs and Border Protection. Each visa category has restrictions on the allowed activities. If a non-immigrant overstays or violates the conditions, they may face removal from the U.S. and be banned from re-entering for a certain period. Now let's look into the immigrant visas. IVs are for individuals who wish to become lawful permanent residents of the United States. LPRs are commonly referred to as green card holders. Immigrant visas are typically available under the following categories: family-based immigrants, who are individuals sponsored by a U.S. citizen or lawful permanent resident. Employment-based immigrants, who are workers sponsored by an employer. And diversity visa lottery, which is for individuals from countries with low rates of immigration to the U.S. Let's talk about the family-sponsored immigrant visa process. It is a two-step process. First, the U.S. citizen or legal permanent resident files an I-130 petition on behalf of the immigrant. Once approved by USCIS, the approval goes to the U.S. Department of State National Visa Center for an immigrant visa. The applicant then submits the form DS-260 and supporting documents. Once the documents are accepted, the applicant must attend an interview at the embassy or consulate in their home country. During the interview, the immigrant's passport gets an immigrant visa stamp. With the stamp on the passport, the immigrant travels to the U.S. and receives the green card in the mail. The two-step process can take close to a year due to the long processing time. Let's look at the eligibility requirements for U.S. visas. To obtain a visa at a U.S. embassy or consulate abroad, applicants must demonstrate eligibility under the Immigration and Nationality Act. The officer at the U.S. embassy or consulate will determine eligibility based on the purpose of travel, supporting documentation, and interview questions. Let's examine the visa classifications. Applicants must show that they fall within a specific visa classification. Examples of non-immigrant visas are B1 for business, F1 for students, and H1B for specialty workers. Examples of immigrant visas are family-based and employment-based visas. Now let's see the visa documentation that is requested. Applicants must submit a completed application, supporting documents like birth certificate, income information, biometric data like fingerprints, police certificate, and passport-style photograph. Let's break down why visa applications can be refused. There are various legal grounds for visa refusal. Criminal ineligibilities like past criminal convictions. Health-related grounds like certain health conditions that lead to inadmissibility. Security-related grounds like ties to terrorism or espionage. Public charge grounds like the risk of becoming dependent on public assistance. Applicants may seek waivers in some cases and avoid a denial of their visa. The officers can ask for a waiver at the interview and provide a paper with the ground of refusal. Now let's review the visa issuance process. Once eligibility is established, a consular officer will decide whether to approve or deny the visa application. The key factors for approval are: 1. The applicant qualifies for the visa type requested. 2. The applicant submitted the necessary documents. 3. The applicant is not barred by any ineligibility clause under the INA. If the applicant is refused a visa, the consular officer will provide the legal grounds for refusal based on the Immigration and Nationality Act. Consular officers cannot refuse a visa based on arbitrary decisions. There is another way to obtain a legal permanent residence. That process is called adjustment of status and is the process that allows individuals who entered the United States legally, either through visa admission or parole, to apply for a green card without having to return to their home country for consular processing. To be eligible, the applicant must have a qualifying petitioner, such as a family member using Form I-130 or an employer using Form I-140. The petitioner files an immigrant petition on their behalf to USCIS. In this section, we'll go over the steps to submit an adjustment of status application. The petitioner files an immigrant petition on their behalf to USCIS. Once the petition is approved, the beneficiary may apply for a green card using Form 1485. In certain family-based cases, such as a petition filed by a U.S. citizen's spouse, the beneficiary or applicant may concurrently file the adjustment of status application at the same time as the petition. The green card application package also requires an affidavit of support, which is Form I-864. This is required to prove that the applicant will not need government-funded benefits, and the sponsor will take care of them financially if necessary. The applicant must also submit a medical exam signed by a USCIS panel doctor. Applicants are also eligible to request employment authorization using Form I-765 and advance parole using Form I-131. These processes allow them to work in the U.S. and travel internationally while their green card application is under review. The green card review process typically takes about 1 year. In summary, to qualify for a green card while physically present in the U.S., the applicant must have entered the U.S. with a visa or parole and have an I-94. Meet all eligibility requirements, submit a medical examination, and have no disqualifying criminal history. Here's a brief recap of this lesson to reinforce what we've learned so far. There are 2 main types of visas: immigrant visas for permanent residence and non-immigrant visas for temporary stays. Eligibility for a visa is determined based on several factors, including the classification of the visa, the documentation submitted, and the applicant's overall admissibility under U.S. immigration law. Adjustment of status is available for people in the United States. That wraps up this lesson. Thanks for watching.